It's a freaky shit. Besides that shit, what's up?
All right, this is case number 2026 CR 24 LHB, State of Georgia versus Jessica Marie Motes. In the indictment, Ms. Motes is charged with malice murder, felony murder, cruelty to children in the first degree, aggravated battery, and concealing the death of another. The defendant is present with Mr. Dowdy and Mr. Law, her two attorneys, and the district attorney's office is present as well. The indictment in this case was filed January 12th, 2026. The death penalty notice, where the state indicated its intention to seek the death penalty, was filed on March 2nd of 2026. And the clerk provided notice to the Supreme Court on April 17th of 2026. The defense counsel filed a motion for continuance on March 18th, requesting that the first proceeding, that being today, not be held until after the autopsy report was provided. And I don't know if the autopsy report was provided.
The autopsy report has not been provided, Your Honor. It has not been completed. I have spoken to Dr. Mayer of the GBI. She was in charge of what turned out to be a team of medical examiners down at the GBI headquarters that have been performed, that took several days to perform the initial autopsy. Subsequent to that, there are many portions of Autumn Fox's body that have had to be set in formalin in order for more testing and evaluation to be done. Dr. Mayer has shared with me her informal opinion as to the cause of death, and that was what we based our indictment on. However, the completed GBI medical examiner report has not been completed, and as of yesterday, I've been trying to talk to a Dr. McCullough, who's also one of the medical examiners, but I can't tell Your Honor that it's going to be a month, 2 months. I know that it is a lengthy process where they have to set human tissue in formalin in order for it to set up, or in the case of the bones, this child's bones that they're examining, to soften. They're in the process of all of that, so it is still ongoing. The state apologizes. It simply have been unable to get a final autopsy report as of yet. Of course, the second we do get one, it'll be passed on to defense immediately.
Well, and the court simply can't continue the first proceeding any further than today because it would delay the trial to a much later unknown date into the future. Mr. Law, I know that you first filed motions on December 31st of 2025, discovery motions, and you've made an announcement earlier that you've received all discovery but for the autopsy report.
That's my understanding, Judge. The other thing I was going to, when I filed that motion, I'd looked through the checklist or anything else. My major concern today is that, as I read the rules, arraignment is supposed to take place after a first appearance.
We would be setting the arraignment today.
Okay, as long as we're not doing both today, I
We are not doing both
anything
today.
else to say. But I will emphasize one of the things I was going to discuss the most today is that the motions that we file will be radically affected by having the autopsy. And so I can't emphasize how much we need that autopsy to make strategic decisions That's all it is in terms of my motion for continuance.
Well, and what I'll do today is set an arraignment date, and we'll pencil in dates for motions, non-evidentiary motions. And Mr. Law, at the time of arraignment, if you need additional time to file motions based upon the fact that you don't have the autopsy report, I would be open to considering additional time. But I do want to get some dates on my calendar so they don't get eaten up with anything else.
Yes, ma'am. And when you want to hear from me, the only other major thing I was going to mention today, and you can hear from me now or later, both Mr. Dowdy and I are death penalty qualified.
Yes.
I'm on the case. I probably need to put on the record my qualifications.
I knew that you were retained, and I knew that you and Mr. Dowdy have both participated in death penalty cases before. The rules really talk about appointed counsel having certain qualifications, but I would appreciate any qualifications that you and Mr. Dowdy can put on the record. I think that will assist.
Do you want us to do that now?
You can do that now.
Judge, I have been co-counsel on a month-long death penalty case years ago. It was the State versus Bromley. I have been lead counsel. I know.
Pause right here. This is where things get serious. When attorneys start listing death penalty experience, it's not just formality, it's survival strategy. In capital cases, every detail matters because one mistake can cost a life. And notice this. Even the defense is admitting it's been years since handling something this big. So the real question is, are they fully prepared for what's coming?
On at least 2 murder cases and multiple capital felony cases, State versus Step murder case, and one other murder case years ago, and I've had others. But it's been, and I was also co-counsel on another death penalty case, State versus Lee Ryder. But Mr. Ryder died before the case could receive a resolution. It has been many years, and both Mr. Dowdy and I have to agree to take the 10 hours of training. I think that applies to us. I was going to ask the court if it does. I'm planning to take it anyway. You could continue an education specifically about death penalty cases. Because it's been so long since I've handled a death penalty case, my client is indigent. We were retained by her father. We're asking that she be appointed one other attorney. Presumably, they might hand it off to the death penalty defender's office, but that would speed up the resolution of the trial. It would fine-tooth what motions need to be filed. As of today, going through the checklist, without having the autopsy, we would say every possible motion that could be filed will be filed in this case. But we are asking for that, and it also relates to, I don't know when the death penalty defender is on a case what inherent resources they have for experts. Assuming we don't have access to anything through that, we will be filing motions for funds for experts. And I'll state on the record, she hasn't worked in 4 years. She's been in jail for months on this case. I don't think there'll be any issue of fact about her being indigent.
And so we will certainly send your request to the Capitol Public Defender's Office, and I'm going to ask that you reach out to them first to ask whether or not any specific procedure needs to be followed for you and Mr. Dowdy to remain on the case, but also have the resources of the Capitol Public Defender's Office. I don't know their procedure or policy in regards to that, but I think we need to figure that out quickly.
Judge. I anticipated that, and I've talked to a current member of the Death Penalty Defender's Office as well as a retired member has offered his assistance. So I will get to the bottom of that and make a report to the court.
And the question that I would have specifically is if the Capital Public Defender's Office is also appointed, as the two of you were not appointed but have been retained for a limited purpose, does that open the resources that they have to investigators and presenting mitigation evidence, et cetera?
Yes, ma'am, I will specifically ask that.
Excellent. And Mr. Dowdy, do you want to put your qualifications on the record?
As they are, Your Honor. My last murder case was last year. It was not a death penalty case. I participated in 3 death penalty murder cases in my career, but it's been some time back, and probably have not been involved in one in more than 25 years. Routinely handle major felony cases, but being that there are certain qualifications, I want the court to be aware of that.
Thank you. All right, copies of the Uniform Appeal Procedure are being passed out now and are being provided to the state, the defendant herself, both defense counsel as well as the court reporter, and I'll sign a certificate of distribution ensuring that that's placed on the record. The court and the court reporter will ensure that all proceedings are completely transcribed. Again, as it's already been mentioned by Mr. Law and Mr. Dowdy, I'm encouraging all parties and attorneys, instructing you to read and adhere to the Unified Appeal Procedure. For counsel, the outline and checklist are to assist defense counsel in protecting the defendant's rights, but of course it remains the responsibility of counsel to protect those rights, and the outline and checklist don't take the place of diligent counsel representation that I have no doubt Mr. Law and Mr. Dowdy will provide. Discovery has already been filed for. That was filed for back on December 31st. And it appears that the state, and Mr. Buckler, you stated that the only piece of evidence that is outstanding is the autopsy report. Does that remain accurate?
That's correct, Your Honor. To my knowledge, after discussions with Special Agent Still at the GBI, when I turned over, Mr. Law came by and gave us a drive when I made a complete copy of everything that we had. What I did fail to do, as Your Honor has probably noticed, is file a certificate of service for the discovery. What I'll do is go ahead and file one.
And this right here could change everything, the missing autopsy report. In a murder case, that report is the backbone of the entire prosecution. No clear cause of death means uncertainty, and uncertainty creates doubt. So ask yourself, can the state really push forward without it, or is this a ticking clock that could reshape the entire case?
Now, today, indicating that discovery has been turned over, and I will go ahead and update the court when I have a better idea of when we can expect the autopsy report, and of course, let defense counsel know about that. And of course, if there's anything else that anyone believes that we should have turned over, let us know and we'll make sure to do that.
Thank you, Mr. Buckler. I'd also remind both parties that with the reciprocal discovery, now that it's been opted in for, information provided by both sides should certainly be accurate and thoroughly complete. Mr. Law, do you intend to present a challenge to the composition of the master jury list or the manner in which the grand or traverse jury is drawn?
Yes, ma'am.
All right, then I'm going to be setting a date for that hearing. I don't believe that will be impacted by any sort of autopsy report, so I'm going to set a date once I have an opportunity to look. I might set a date today. And in reviewing the checklist to determine which pretrial issues you intend to raise, at this point, Mr. Law, because you don't have the autopsy, you're stating that you're considering every motion on the checklist until it can be narrowed based upon that autopsy report.
Yes,
if it
Judge.
can be narrowed.
Yes, Judge.
All right. And again, while issues that are not raised at arraignment generally are waived, again, Mr. Law, if you're requesting additional time to file motions based upon not having the autopsy report, just file something at arraignment so that I can consider that request.
I will do so.
And of course, defense counsel is instructed to locate and interview all persons whose testimony might be helpful or in supporting any theories of defense or mitigation of punishment. In regards to arraignment, I'm going to set arraignment for July 8th at 9 a.m. I'm going to set the date for any challenge to the jury. We'll set that for August 3rd. And my experience with death penalty cases as well as murder cases is that there are a number of motions filed that can be addressed without witnesses simply by argument of counsel. And so I want to set several days for those motions first so that we can handle the bulk of those without any witness presentation to address a significant number of motions that I expect would be filed. So for those dates, I'm going to pick September 18th and September 28th. And again, it doesn't mean that we have to use both dates. Let me check that one more second.
28th, yeah.
No, 18th, yeah, 28th.
Actually, for the non-evidentiary motions, I'm going to pick September or August 7th and September 4th. Again, we may not need both of those dates, but that will allow me just to mark the calendar off so that I don't book it for anything else. For evidentiary motions, I don't have consecutive days on my calendar available, and so what I intend to do is, if additional time is not necessary, Mr. Law, is use my trial week for the week of October 5th for any evidentiary motions, and we just go until we finish them. I can't imagine it would take more than a whole 5 days, but if so, I'll find additional days. But those are the dates right now, and we'll issue a scheduling order that has all of those dates. Does anybody know from their calendar right now that some of those dates won't work because of a leave of absence that's already been filed?
I don't have any leave of absence for those dates.
All right. Mr. Dowdy, you're okay too?
Yes, ma'am.
All right. All right, Ms. Moats, do you have any problems, any issues, any objections to the attorneys that you are being represented by today? Mm-hmm. And do you have any objection to the manner in which they are conducting your defense up until this point? Mm-hmm. And Ms. Moats, is there anything else any other concerns that you have that you want to raise today? All right, then I'll see everybody back on July 8th for arraignment, and if the district attorney's office will notice my office with an email CC to Mr. Law when and if the autopsy report comes back prior to July 8th. Obviously, I don't want to review the autopsy report. I just want to know simply whether or not it's been provided.
Yes, Your Honor.
And Your Honor, if I may, you said July the 8th.
Yes.
Will the court permit me to, when I get back, check my calendar for that date? Because I think my wife might have had some planned.
Absolutely. You let me know, and if we won't finalize the scheduling order until we hear from you to ensure I have more availability throughout the summer to schedule a arraignment date.
Yeah, I think it's later on in the month, but I want to be sure.
No problem. All right, is there anything else that we need to address today at the first proceeding?
Nothing for the state, Your Honor.
Nothing for the defendant.
All right, then we'll conclude State versus Jessica Marie Moats and Ms. Moats. I'll see you back in a few months for arraignment. You're excused. Thank you. And Mr. Mr. Dowdy, will you file an entry of appearance? I don't know that that's been filed yet.